used for your business. And benefits of licensing can generate revenue streams, enable market expansion, facilitate strategic partnership for startups. Now, in case of market expansion, the franchising model is a traditional one. So, if you are, thinking about expanding geographically, you can consider licensing your trademark or your brand, or asking people to indulge in this licensing thing, so that geographically also in some other state, you're operating from one particular state, say you're operating from Maharashtra, you want people in Rajasthan to also know about your brand and the products that are being created. So as for a traditional way, it's very time taking and a tedious process, and also very financially exhausting if you yourself go and take up a building infrastructure, invest in it, and then create a identity over there. So the easier way and a cost-effective way would be to license your brand to a licensee who will be using your brand and selling your products, but paying you recurring royalties, but won't be having any exclusive rights over your brand. So structuring these kind of licensing agreement is a very key element for getting a successful revenue out of your registered trademark or a patent or designs. So that is the grant clause, the royalty clause, the duration for how long this license is being provided, jurisdiction, trademark licensing, and post-termination rights. Post-termination rights is also very important. So post-termination is nothing but if your agreement is over or the agreement is terminated midway, so the licensee does not have any right to claim over your business model or your logo, so on and so forth. So it provides a protection that the licensee doesn't misuse your brand in some other jurisdiction. Any questions?
Ma'am, is it similar to buy a franchisee of the startup?
See, a franchisee model is basically the traditional one through which this licensing agreement has come. So it's a more modernized version. So in a licensing agreement, you have the freedom to put in structuring these clauses, which is more effective. You can obviously go for a franchisee, also works in the same way, similar way. But if you are going for the licensing thing, you have the freedom to put in your structured things.
Okay, ma'am. Thank you.
So, and also the royalties can be planned. So it's not that just for using your logo or promoting your business, the licensee is giving you royalty. Right. What you can do as a startup, if you are giving a franchisee, so if he's selling your products, you are claiming some royalty over the profit. And for the IPR protection, you can also go for another licensing agreement where you are licensing that franchisee. Herein the agreement, he is the licensee, you are licensing that franchisee to use your IP assets. So he is using your logo and your brand name. So that is the licensing agreement. So keeping two separate agreements would be a better way to go. One for running of the business and one for usage of the brand identity and usage of the logo, so on and so forth. Is it clear?
Yes, ma'am.
Okay. So this is we can like I said, the hybrid approach to IP management. So first thing is you have to acquire patent rights in one country and you can license them in some other. Like I said, if not country, it can be in a if it is in the similar country, if you're acquiring patent rights, you can license someone from different states, different people from different states to be using them in exchange for royalty. And if you want to go country-wise, suppose you want to apply the patent first in your home country, definitely, and maybe you want to apply the patent in Russia, you want to apply the patent in Bangladesh, you have to apply for separate patents through their IPR portals. So if you want rights in those countries, if you don't want rights in those countries and you're happy with just the patent in your home country, you can give licenses to foreign citizens also to conduct the usage of your brand and your products, or license to a shopkeeper to keep your products over there or use your brand. Is it clear? Okay, so I'll move on to the trademark licensing, which I had already previously said that you can license anything. Other parties, they'll be doing part of the business for you, but you will be retaining the ownership. Similar thing for copyright, so usage of software or content in exchange for royalties. Trade secret licensing is like if your trade secret is being leaked or if somebody is seeking any kind of trade secret in order to establish their startup, that's a huge no-no. So whatever confidential information, limited confidential information is being shared with people to licensees, then it has to be trade secret licensing. But I would still suggest not fully licensing your trade secrets, as it imposes a huge risk on your business strategy, your business models being exposed and misutilized. So limited licensing of trade secret is the way to go.
Hello.
Yes, please.
Okay, ma'am. Let's suppose for a moment, if somebody has taken a license in India for any business, and then they have seen that whole business on any platform, maybe on social media, and now that particular person is taking that same license in their own country. So is that valid? They can operate that similar business in different country, copying from India?
I did not get your question. So suppose we have, please repeat your question once.
I'm asking, let's suppose if I have taken a trademark in India for any particular business, somebody has seen me on any social media platform, and now that particular person planning to copy my idea, and they have registered in their own country, so they can operate that similar business in their country.
See, if they can operate, but the thing is, since you have a registered Indian trademark, if you have a registered trademark, firstly, that is the greatest protection. If you have a registered trademark, you can approach a IPR attorney in their country, give your registered trademark details, and send them a infringement letter or a cease and desist letter. Simultaneously, you can also write a letter to the IPR, the IPR controller or the IPR trademark registry in that particular country or the trademark office. You can write a letter with the help of the IPR attorney that you have appointed, and you can make them know that it is a complete infringement of your trademark, which is registered in a different country, definitely. So they can give it a consideration before, but you have to ensure that this is done before the other trademark